We will go on the record in the matters 24 CF 219, 25 CF 09, 25 TR 30, State of Wisconsin versus Austin Bruss. The state appears through Assistant District Attorney Holly Rockow, Defense Counsel Eugene Harrington, and Austin Bruss, all in person. We're set today for status conferences and a preliminary hearing. Off the record, Defense Counsel indicated this will be a waiver of a preliminary hearing. Is that correct, Mr. Harrington?
That's correct, Judge.
Officer is released. Mr. Bruss, do you understand what it is to have a preliminary?
The Wisconsin courtroom. The case of State of Wisconsin versus Austin Ross is called. The state, defense counsel, and the defendant all appear in person. This day was set for status conferences and a preliminary hearing, but off the record. Defense counsel confirms it will be waived. The judge explains in detail what a preliminary hearing is, a chance for the state to prove a felony was likely committed by the defendant. Austin listens carefully, acknowledging each right he is giving up, with his waiver accepted. The matter is bound over for future proceedings. Subscribe for more courtroom stories.
From the state's witnesses or call witnesses to testify for you, you would have the right to testify on your own behalf or remain silent and not have your silence against you. Your attorney would also be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses. Do you understand that by waiving your right to a preliminary hearing, you're giving up those rights for this hearing only?
Yes.
Do you understand that if the state does not meet its burden as to the felonies, I could amend them to misdemeanors or dismiss them altogether, but you're giving up that right today?
Yes.
Do you understand that as a result of waiving your right to a preliminary
The judge
hearing,
explains to Austin that at a preliminary hearing, he could have cross-examined witnesses, presented evidence, and testified or remained silent. She reminds him that if the state failed to meet its burden, charges could be reduced or dismissed. Waiving this right means he can never get it back. Austin confirms no threats or promises influence his decision. The court finds he acted freely and intelligently, then enters not guilty pleas on his behalf. Address and phone details are confirmed, and a status conference is set for March 24th at 2 p.m. The case moves forward.
this matter will be bound over to future proceedings, which could include a trial?
Yes.
Do you understand that once you give up the right, it is forever and you cannot get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing.
Yes.
I will find that you are competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and find the matter over. Information, Ms. Rockow.
Your Honor, I'm just filing it now. It mirrors the charges contained in the criminal complaint.
Proceed with an arraignment or set for another date.
Today.
He understands charges and
The court calls State of Wisconsin versus Ronald Ritchie. The state appears ready for a preliminary hearing, but the prosecutor makes a surprising move, requesting dismissal of count 1, the sole felony, citing insufficient evidence to prove the charge. The alleged burglary from November 2024.
penalties.
Yes, Judge.
Waives formal reading.
Does.
Not guilty pleas.
Yes, Judge.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Are you still on Oak Street West lot number 29?
Yes.
Telephone still ends in 1558.
Yes.
May we still continue to send you text message notifications?
Yes.
All right. Would you like to set this for a status conference sometime in the near future, Mr. Harrington?
Yes, Judge.
Let's do your March 24th at 2 p.m. March 24th at 2 p.m.
That's the same time as Papel. You want to?
Claim the defendant entered a dwelling without consent to steal heat. The judge agrees to dismiss count 1. No preliminary hearing is needed now, and the case appears to be heading toward resolution. On the remaining charge, the court's focus shifts toward restitution and the path forward.
Stack those?
Yes,
Or?
I'm not stacking Winquist, but I'm going to stack the 2 p.m. All right, well, we will see you then. Bond continues.
Thank you.
Thank you.
Richie is going to be a waiver. Actually, sort of, we have that case resolved if Mr. Ritchie shows.
We will go on the record in the matter 24 CF 244, State of Wisconsin versus Ronald Ritchie. This state appears through Assistant District Attorney Holly Rockow, in person. We have Eugene Harrington, defense counsel, in person, along with Mr.
The
Rich.
judge notes the $250 cash bail posted and asks about victim identification and restitution. These details are essential before resolution can proceed. Defense counsel explains that discussions are underway with the prosecutor, awaiting an inventory of property, calculating value, and finalizing terms. Both sides believe a resolution is likely, but some details remain unsettled. The timeline for completion is debated. March 24th seems too soon. The court and counsel begin exploring alternative dates for a potential plea and sentencing.
We're set here today in this matter for a preliminary hearing. How is this matter proceeding, Mr. Harrington?
Ms. Rocco, go ahead.
Your Honor, this won't be a preliminary hearing today. The state is moving to dismiss count one, the sole felony in the criminal complaint. I believe that we're moving towards a resolution. I don't believe that the state can prove that count, and therefore I think it's appropriate at this stage to simply dismiss that. The state's going to gather some additional information via
The next focus. The court proposes April 2nd, but counsel suggests March 31 might be better, aligning with another case already set for that day. The judge offers a 2:30 p.m. slot on March 31st for a plea and sentencing hearing. If an agreement is reached by then, the case will be resolved. If not, another date will be chosen. The $250 bail posted will first go toward restitution, should any be ordered, before covering court costs or fees. Everyone acknowledges the plan, and the courtroom moves to its next matter.
law enforcement and the victim. There may be an amended criminal complaint filed, but for now, the state is just proceeding on count two.
All right, thank you. And now I'm looking at count one, burglary of a building or dwelling, and that alleges on or around November 23rd, 2024, that the defendant intentionally entered a dwelling owned by RB without the consent of the person in lawful possession of that place and with intent to steal, quote, heat, end quote. And so that's the basis for the request to dismiss.
Yes.
The court will grant that motion to dismiss. Therefore,
Waiving the preliminary hearing was a strategic choice, avoiding early testimony while pushing the case toward trial preparation. For Ronald Ritchie, the dismissal of the felony charge drastically changed the legal landscape, leaving only a lesser charge to resolve. In both cases, the court ensured each defendant understood their rights and the consequences of their decisions. These procedural moments, though quiet, can determine the direction of a case toward trial, dismissal, or negotiated resolution. The stakes remain high as both men await their next hearings.
we do not need to have a preliminary hearing in this case, and the matter appears to be working towards a resolution. We do have $250 cash that has been posted as bail. I do not have any request or anything notifying the court that I don't have a victim key identifying who the victim is, nor do I have any restitution supplement identifying if there's any restitution being requested. And the court's going to need to know those things before we move towards a resolution. Mr. Harrington, looking
The
at
process is deliberate and measured, waiving rights, dismissing charges, and scheduling hearings may seem procedural, but they shape the outcome of criminal cases. For the defendants, these are pivotal junctures. One wrong step could close the door on opportunities for reduced charges or favorable resolutions. For prosecutors and defense attorneys, every decision is strategic, balancing legal burdens with evidentiary realities. As the gavel sounds, today's outcomes are set, but the full resolution lies ahead in the months to come.
we will schedule it for a plea and sentencing. Hopefully it can reach resolution by then. If not, we'll just reschedule for another date. But again, there's $250 posted. So if there is restitution, that would first go towards restitution before it goes towards court costs and fees.
Clerk will give you a notice. You want to wait outside just a couple of seconds?
Mr. Ritchie, is your address still on Johnson Street with P.O. Box 125? Is that a yes?
Yes.
And does your oh, and I updated it. Never mind, we're good to go.
Two different turns. One waives a hearing, the other loses a felony count. Yet both remain in the justice system's hands, moving toward resolution. These proceedings reveal the intricate balance between legal process and negotiation for viewers. They're a reminder that courtrooms aren't just about dramatic trials. They're about choices, timing, and strategy. If you enjoyed this behind-the-scenes look at real court proceedings, be sure to like this video, subscribe to the channel, and stay tuned for more stories that bring you inside the legal process as it unfolds.